Renee, good. Welcome back. Today, we need to have a very serious, strictly legal conversation about the shooting of Renee Good in Minneapolis. We are going to put aside the political noise for a moment and look at this through the lens of criminal procedure, forensic ballistics, and the constitutional standards established by the United States Supreme Court. As lawyers, we know that video evidence can be subjective, but in this specific case, there is a sequence of frames that changes the entire legal landscape for the federal agent involved. I am talking about the trajectory of the bullets, specifically the shots that entered through the side window of the vehicle. In any officer-involved shooting investigation, the defense will immediately invoke the standard in Graham v. Connor. This 1989 Supreme Court case established that an officer's use of force must be judged by an objective reasonableness standard. The court famously held that we must judge the officer's actions from the perspective of a reasonable officer on the scene, rather than with the 20/20 vision of hindsight. They argue that allowances must be made for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. However, Graham is not a blank check. It does not grant immunity for actions taken after a threat has ceased, and this is where the video evidence in the Renee Good case becomes legally catastrophic for the defense. We know there were 3 shots. The first shot may have been fired through the windshield as the vehicle began to move, but the subsequent shots entered through the driver's side window. Why is this the most dangerous piece of evidence for the agent? Because of geometry and physics. For a bullet to enter the side window at a perpendicular or rear-facing angle, the vehicle must have already passed the shooter. This brings us to the critical legal concept known as the cessation of threat. Under the Fourth Amendment, the authority to use deadly force ends the moment the immediate threat to life ends. If the car is moving towards you, it is a weapon. If the car has passed you and is moving away, it is no longer a weapon directed at you. When that agent pivoted his torso to track the vehicle as it passed him and continued to fire into the side glass, he was no longer stopping an oncoming threat. He was firing at a fleeing subject. This moves us out of the protective territory of Graham v. Connor and directly into the violation of Tennessee v. Garner. In Tennessee v. Garner, the Supreme Court ruled that it is unconstitutional to use deadly force to prevent the escape of an unarmed fleeing suspect unless the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical injury to the officer or others. The defense will try to argue that the car itself was a deadly weapon. They will cite Plumoff v. Rickard, a 2014 case where the Supreme Court ruled that officers were justified in firing 15 shots into a fleeing car. But any competent prosecutor will distinguish Plumoff from the facts here. In Plumoff, the suspect was involved in a high-speed chase exceeding 100 miles per hour, actively swerving and endangering the public. Renee Good was not in a high-speed chase. The video shows the vehicle moving slowly, essentially just beginning its acceleration from a stopped position. It was not careening down a highway, it was maneuvering at low speed. The imminent public danger exception found in Plumoff simply does not apply to a vehicle moving at 5 or 10 miles per hour away from an agent. Furthermore, we must address the reaction time defense. The defense will argue the OODA loop: observe, orient, decide, act. They will claim the agent decided to fire when the car was coming at him, and his brain simply couldn't stop his finger from pulling the trigger as the car passed. This argument fails when we look at the mechanics of the shooter. The video shows the agent physically turning, tracking the target. Tracking is a cognitive motor control action. It implies a continued intent to engage. When you turn your body to fire into a side window, you are making a new decision to shoot at a target that is no longer in front of you. That is not a reflex. That is a decision. This distinction is what converts a case from self-defense into what the law might classify as voluntary manslaughter or even second-degree murder. Self-defense requires an imminent fear of death or great bodily harm. A car driving away from you does not present that threat. By firing into the side window, the agent was effectively executing a summary judgment for the crime of flight. Federal agents are also bound by the Department of Justice's own deadly force policy. That policy explicitly states that firearms should not be discharged solely to disable a moving vehicle. It further states that agents should not fire at a moving vehicle unless a person in the vehicle is immediately threatening the agent with deadly force other than the vehicle itself, or if the vehicle is being used as a weapon and the agent has no way to escape. The video shows the agent standing to the side. The vehicle passed him. He was clear. The duty to retreat does not apply to officers in the same way it does to civilians, but the opportunity to disengage is relevant when assessing the necessity of lethal force. If the car passes you, the necessity of killing the driver to save your own life has evaporated. So, legally, those side entry wounds tell a story of an agent who was angry, not afraid. An agent who was punishing non-compliance, not preserving life. And under the laws of the United States, non-compliance is not a capital offense punishable by summary execution.
Now, we must pivot from the forensics of the street to the forensics of the statement. While the ballistics tell us what happened to the body, the statements coming from the highest levels of the United States government tell us what is happening to the rule of law. We have heard the Department of Homeland Security classify the actions of Renee Good as an act of domestic terrorism. We have also heard President Donald Trump explicitly state that the agent acted in self-defense and that the deceased intentionally hit the officer. From a legal standpoint, these are not just press releases. These are potential obstructions to a fair and impartial investigation. They represent a collision between the executive branch and the judicial process that is rarely seen in American history. Let's start with the Department of Homeland Security's classification of this incident as domestic terrorism. Under the USA Patriot Act, domestic terrorism involves acts dangerous to human life that are a violation of the criminal laws, intended to intimidate or coerce a civilian population or to influence the policy of a government by intimidation or coercion. By applying this label immediately, before an investigation is complete, the DHS is attempting to fundamentally shift the burden of proof in the court of public opinion. They're trying to move this case from the jurisdiction of criminal negligence and homicide into the realm of national security. This is a tactical legal maneuver. If the victim is a terrorist, the rules of engagement change. The public tolerance for lethal force increases. It is an attempt to retroactively justify a use of force that the video evidence contradicts. But the even more significant legal issue arises from the comments made by the President of the United States. When the President declares that the agent acted in self-defense, he is issuing a verdict before a trial has even begun. This creates a constitutional crisis known as unlawful command influence. While this term is typically used in military courts under the Uniform Code of Military Justice, the principle applies here. The FBI and the Department of Justice, who are responsible for investigating this shooting at the federal level, ultimately report to the President. When the chief executive publicly declares the suspect innocent, he places immense pressure on his subordinates to conform to that conclusion. How can a federal prosecutor impartially investigate an agent when their boss has already announced the result? We have precedent for the chaos this causes. In 1970, President Richard Nixon famously declared regarding Charles Manson, "Here is a man who was guilty, directly or indirectly, of 8 murders without reason." Nixon said this while the trial was ongoing. The defense immediately moved for a mistrial, arguing that the president's words had prejudiced the jury and made a fair trial impossible. It almost destroyed the prosecution's case. More recently, in the case of Bo Bergdahl, defense attorneys argued that comments made by Donald Trump and John McCain constituted unlawful command influence, making a fair hearing impossible. The courts take this very seriously. A president's words carry the weight of the state. In the case of Renee Good, the president's assertion that she intentionally hit the officer is a statement of fact that is currently in dispute. If a state prosecutor in Minnesota brings charges against this agent, the defense will use the president's words to argue that the federal government has already investigated and cleared the agent. They will argue that the state prosecution is a malicious, politically motivated witch hunt, contradicting the findings of the commander-in-chief. Furthermore, these statements implicate the Supreme Court standard set in Shepard v. Maxwell in 1966. That case established that a defendant is denied due process if virulent publicity prevents a fair trial. Usually, Shepard is used to protect the defendant from a media lynching, but here we have a reversal. The virulent publicity is coming from the government itself to protect the shooter and demonize the victim. If a jury pool is saturated with the message that the victim was a terrorist and the president has personally reviewed the tape and cleared the agent, finding an impartial jury becomes a nightmare. This effectively poisons the jury pool, which is a violation of the Sixth Amendment right to a fair trial, not just for the accused, but for the interest of justice itself. We must also consider the concept of qualified immunity. Federal agents are often shielded from civil lawsuits unless they violate clearly established statutory or constitutional rights. By framing the incident as a response to terrorism, the administration is laying the groundwork to grant this agent absolute immunity from any civil liability the Good family might pursue. They are building the legal wall right now, brick by brick. In conclusion, what we are witnessing is not just a shooting investigation. It is a stress test of the American separation of powers. We have video evidence that suggests a violation of the Fourth Amendment via excessive force on a fleeing subject. Against that, we have the full weight of the executive branch attempting to redefine that flight as an act of war. As legal observers, we must reject the noise and focus on the statute. Did the agent have a reasonable fear of imminent death when he fired the second and third shots? The law says no, and no press release, no matter who signs it, can change the trajectory of those bullets or the letter of the law.